The Supreme Court of Nigeria has dismissed an application by Shell Petroleum Development Company after the oil company contested a January 11, 2019 order to pay 17 billion naira to some Ogoni communities in Rivers State who were affected by an oil spill in 1970. A five-man panel led by Justice Olabode Rhodes-Vival unanimously dismissed the company's application for review of the judgment. Justice Sentus Nweze prepared Friday's lead ruling, which was read by Justice Chukwudumebi Oseji, who is not a member of the five-man panel. Now, joining me on the news for more on the Supreme Court's ruling are lawyers Usman Yakubu and Tolulope Aderemi. Thank you very much for joining us on the news.
Thank you for having me. Yes.
Now, thanks for joining us. What does this ruling by the Supreme Court mean for Shell, considering that the lead lawyer for the communities, Lucius Igwe, says the accrued interest for the 32 years stands at about 182 billion naira?
Thank you very much. Essentially, what it means is there is a substantive judgment of the Federal High Court awarding the sum of 17 billion naira and a 25% post-judgment interest sum on that judgment. Now, because it spanned 31 years, actually, the 25% post-judgment sum is what has accrued to 182 billion naira. But let me say that, yes, Lucius Nweze was not wrong in that assessment. But that's not to say the judgment or the substantive decision can still not be appealed. And I'll tell you what that means. So what the Supreme Court has decided upon now is almost an interlocutory point and not the substantive judgment of the Court of Appeal. So at the Federal High Court, Shell appealed that 17 billion judgment to the Court of Appeal. Now, the grounds of that appeal was mixed law and fact. And the law is that when it's grounds of mixed law and fact, then the appellant must seek the leave of court to be able to file such an appeal. Unfortunately, that was not the case. And for those reasons, the Court of Appeal decided in favor of the community. Now, when the learned essay Olanipeko came on board, they filed the same application seeking the leave to amend the notice of appeal of the Court of Appeal. Unfortunately, the Court of Appeal took that decision that you can't place something on nothing. The appeal before us ought to have been one that was sought by the leave of court for us to be able to sit or to assume jurisdiction on. And to the extent that that was not the case, then the Supreme Court was bound, by its own laws. And then the same application was filed at the Supreme Court, seeking to also amend that notice of appeal, but this time around to now file 32 additional grounds of appeal, such that the Supreme Court can now sit, perhaps maybe almost in its original jurisdiction, to look at that. Now, in January, the Supreme Court also agreed with the Court of Appeal that to the extent that leave of the lower court, which is the appellate court, was not sought before the notice of appeal was filed, then it makes such an appeal incompetent in law. And for those reasons, it was unable to agree with Shell that decision to set aside that appeal on that point be set aside. Note the point, the substantive decision of the Federal High Court has not been litigated upon or appealed against.
Thank you very much, Mr. Aderemi. Now, can this amount of money that is to be paid by Shell to the community make up for the years of damage caused by these communities, or is it just symbolic? The material sum that has been awarded in judgment, would it go a long way in fixing things in the community?
Well, essentially, you look at it from two perspectives. And this is maybe partly some of the problems that we have in the littoral states in terms of compensation. So when you have a liquidated damage sum, it's a damage that can or ought to be compensated in monetary terms. But the challenge in the oil-driven areas is such that it has denied people of livelihood, is taking their jobs, etc. So you need an organized community to be able to warehouse these funds. 182 billion naira is a lot of money. And I must add that there was a garnishee order NISI, which the court actually granted. And CBN was almost pleading that, look, we can't release this money, because if we do release this money, it's going to hurt the economy. And so if you release 182 billion to the river, the Tolulope local government alone, it's going to go a long way in fixing whatever may have been the damage suffered. However, to the extent that there's no organized community or vehicle that will warehouse and administer this money, then I am not sure it might just prove.
Okay. Now, finally, does Shell have any other moves to delay the payment? The Supreme Court has passed judgment, and we know that's the apex court in Nigeria.
I beg your pardon, does Shell have what?
Does Shell have any other moves left to delay payment since judgment was given by the Supreme Court, which is the apex court in Nigeria, to delay payment or appeal in any other form?
Well, regrettably, to the extent that the Supreme Court is the final court, like you possibly know, it's not likely that Shell has any other option, other than to comply with. If they had sought the leave of court at the Court of Appeal level, the substantive decision of the Federal High Court may be what we may be discussing today. But unfortunately, that was not done. And the Supreme Court has now affirmed the lower court, which is the Court of Appeal's position, that having not sought leave on mixed law and fact, then it is unable, to agree otherwise, that the Court of Appeal was right in dismissing that appeal.
Thank you very much for your time, Barrister Aderemi. You're watching News Central now. When we return, we'll bring you more on the latest news on the African continent. Do stay with us.